you don't mind standing with us for the opening prayer, followed by the Pledge of Allegiance. I would like for everyone gathered here in this assembly and all of those who are listening to us at home, if you could please give us a moment of silence. We had one of our longtime county employees, Mr. Art Kellum, passed away recently and very unexpectedly. Mr. Kellum had been with us for 30 years, worked in our roads department, was one of our road supervisors, will be sorely missed. Our thoughts and our prayers go out to the Kellum family. So if you wouldn't mind standing with council and giving us a moment of silence, followed by a brief prayer and pledge of allegiance. Thank you, God. We ask that your grace and mercy and comforting hand be upon the Kellum family this evening as they go about their business of remembering their departed loved one. We ask that you be with them and strengthen this family. And also we ask that you be with the Roads Department family as well. We ask that you strengthen them and give them all the love and comfort that they will need as their passing of their colleague. We ask that you continue watching over and guiding that department as they go about the business of keeping the roads and highways safe here in Talbot County. Lord, we ask that you continue looking over this council and this body as we go about doing the business of this county. We ask that you will strengthen us and increase us as we go along your way. These things we pray in thy name. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. Good evening, and thank you for being with council today. We have several items on our agenda. We're sorry. We do apologize for being a tad bit late. We had a very lengthy closed session agenda. We had a number of legal matters to go through with our county attorney. Again, we certainly ask for your apologies for that. Council has an agenda before us. The chair would ask if there's any additions, deletions, or corrections to the agenda.
Just one addition that I'd like to add to the agenda. There was a call that was placed in front of county staff with a couple of us, and I would just like to put that on the record. And I'd like to do that just right at the beginning, get it out of the way after disbursements.
You want to add this on as a closed session item?
If we could.
If we could we put it on closed session item?
Yeah.
Okay. Any other additions, deletions, or corrections to the agenda? Yes, Mr. Hollis.
Council, you need to push the mic to speak.
Okay, my finger is on the mic.
So we're getting numerous texts from various people.
Okay, Mr. DeVillio, you must make sure you keep your finger on that button, please, while you're speaking. Okay. So we're going to add on to, Madam Secretary, we're going to add on to the an update from Mr. Villio dealing with a phone call. Let's put that right before public comment. Right before county manager. Apologize.
I don't think that should be.
Okay.
May I ask?
If there's no other additions, deletions, or corrections, the chair would move that the agenda be accepted with unanimous consent.
Are we waiting till the end of the agenda for that item, Mr. DeVillio?
Yes.
Yes. Council has minutes from the June 9th meeting. We had a chance to go through those minutes. Any addition, deletion, or corrections to the June 9th minutes? The chair would also add that they be accepted with unanimous consent. Thank you. We have disbursements also from August the 4th and August the 11th. We all should have had an opportunity to go through those disbursements. Are there any additions, deletions, or corrections to those disbursements? Hearing none, the chair moves that they also be accepted with unanimous consent. Okay, thank you. Moving on our agenda, we have a presentation for the Coronavirus Aid, Relief, and Economic Security Act, which is CARES, our individual assistance program, and our legal literacy workshop. So we're going to be hearing from Linda Webb, who is the Director of the Department of Social Services here in Talbot County. Also, Rachel Bitter, Esquire. She's a supervising attorney for the Upper Eastern Shore Office of Legal Aid. And there she is, our finance officer also, Miss Angela Lane is also here. Is Miss Brown here with us as well? There's Miss Brown. Okay, Miss Sandy Brown is also in the audience. She may come up at some point. She is Executive Director of Midshore Pro Bono. Sandy, good to see you as well. So, Linda, I'll turn it over to you for just an update of why we're here and what the CARES Individual Assistance Program has done thus far in Talbot County.
Great, thank you so much. I just want to give you a little bit of background to bring you up to speed, give you some information on what's happening currently with the Individual Assistance Program, and then talk a little bit about what's changing in the environment and how we're trying to adapt to that moving forward with individual assistance. So as you all know, the Talbot County CARES Plan for Recovery allows for individual assistance for those who are unemployed or underemployed as a result of COVID-19 and have the following needs.
Linda, I'm sorry, you need to speak literally right next to the microphone.
Okay. Yeah. Is that better? Okay. Okay. So people that have been impacted financially by COVID-19 and have the following needs, which were approved in the Talbot County Plan. Food, which is being distributed through enhanced food assistance programs. Utility bills, rent or mortgage, sheltering for homeless and other services, and legal services for actions caused by loss of employment and debt related to COVID-19. So DSS was asked to work with the county to develop and operate the Individual Assistance Program, for which applications would be received to assist with utilities, rent, mortgage, and limited COVID-related items. A steering committee was developed to create eligibility criteria and an application process, and that steering committee consisted of the Department of Social Services and the county, as well as the Neighborhood Service Center, St. Vincent de Paul Society, and Midshore Behavioral Health. We developed a protocol, an application, and a couple of supporting forms that would be used to verify things like loss of wages, Talbot County residents, and so on. We continue to meet every 2 weeks with the support of the Emergency Operations Center to monitor progress and troubleshoot any problems that arise in that process. We tried to keep eligibility really simple. We wanted to make sure that we got those funds into the community to the people that needed them. So eligibility is, you must be a Talbot County resident. You have to be able to verify that you had a loss or reduction in income because of COVID-19. And we decided that those who were receiving the $600 a week unemployment supplement would not be eligible for COVID-19, CARES assistance while they were receiving the supplement. They were notified in writing that they could come back and reapply once the supplement ended. And we did try to be flexible so that if there was an extraordinary need, even though someone was receiving that supplement, we could consider and assist them with whatever that need was. So the Talbot County Department of Social Services, with support from the Neighborhood Service Center in St. Vincent de Paul, is receiving and processing those applications for individual assistance. Additional support is being provided by Chesapeake Multicultural Resource Center and their newly developed hotline, which I believe was supported by CARES dollars from both Talbot and Caroline counties. Our initial outreach included a press release, which resulted in a front-page story in the Star-Democrat. We did a presentation to the County Emergency Operations Center private sector call. I did interviews with Cassandra Van Hoosen regarding both the individual and business assistance programs on WCEI and Winks Radio. We did an interview for WMDT TV. We've done email blasts to Economic Development and DSS networks, and we distributed flyers at food distribution sites. So to let you know what's happened so far in terms of numbers of applications that have been received and dollars paid, from the 1st of June, when we started the program, through last Friday, August the 7th, we received 134 applications. Now, Many applications include more than one need. So one application may come in for rent and utilities. And we have to establish that the person is a Talbot County resident and they've lost income because of COVID-19, but then we have to take a look at each individual need separately. So those 134 applications that we've received represented 172 different needs. 30 of those applications, representing 32 different needs, have been submitted to the county for payment, and 51 applications representing 61 needs remain in process. To date, $40,027.51 have been paid to vendors on behalf of individuals in need using CARES Individual Assistance Program dollars. So there have been some recent changes in the environment that impact the use of these dollars. The moratorium on evictions ended. We've been in touch with Judge Ketterman at District Court, and she indicated that she'll be hearing the first eviction cases on September the 3rd. In recent weeks, as a result of knowing that that moratorium on evictions has ended, DSS and county staff, including Sheena Van Ornum and the county housing coordinator, and Nancy Andrew, who's the new EOC recovery coordinator, has done outreach with landlords and property managers, the Midshore Board of Realtors, the Small Business Association, individual mortgage lenders, and the district court. In addition, the federal unemployment supplement of $600 a week ended at the end of July. Those who were denied CARES assistance because they were receiving the supplement were advised in writing that they could reapply for CARES assistance when they were no longer receiving that supplement, and we expect to begin seeing those people apply again. Finally, the utility disconnect moratorium has been extended to September the 1st, and we are reaching out to utility companies to make sure that they have information on the program and the application so that they can assist those who are behind in their utility payments. So with all of that happening in the environment and not knowing when these other moratoriums will end or if they'll be extended, we're doing additional outreach, a second wave of outreach that includes. We've just had approved a simplified flyer. It's kind of catchy, catch people's eyes, and gives them the way that they can contact the Department of Social Services and access various services through our phone system and staff on board. We're doing print ads in the Star-Democrat, the Talbot Guide, and the Attraction magazine. We're hoping to get a crawl on the Weather Channel. We're hoping to get public service announcements on the community television station. We've done additional outreach to the faith community. We're doing outreach to the utility companies, as I mentioned. And we've started a collaboration with both Midshore Pro Bono and Maryland Legal Aid that you'll hear from tonight. They each have the application, the verification forms, the information on the CARES Individual Assistance Program, so as they see community members in need, they can also support them in applying for those dollars. So unless there are any questions for me, I will turn it over to the legal specialists. Okay, I will then introduce, I think Sandy Brown from Midshore Pro Bono is here, and Rachel Wolpert Bitter from Maryland Legal Aid. Thank you.
Good evening. As was said, my name is Rachel Wolpert Bitter, and I am the supervising attorney for the Maryland Legal Aid Office, which is here in Easton, but we serve the Upper Shore, but Talbot is one of our counties, obviously. Maryland Legal Aid provides civil legal services throughout the state of Maryland in a whole range of issues, but I mean, the sort of reason that we're here today and partnering with the county is because we were contacted because of all the work that we do sort of throughout the year in regards to housing, avoiding eviction, and working with folks who have either applied for public benefits and been denied or have sort of issues with public benefits and consumer debt collection issues. And so obviously, as Ms. Webb explained, we are now in a situation where folks who have been impacted, have lost work, are no longer getting additional benefits, and we know that the failure to pay rent evictions cases are going to begin to be scheduled. Okay, sorry. Again, so when Ms. Webb said that the first hearings will be September 3rd, those are the failure to pay rent hearings. There are still, since July 25th, there are evictions that can be happening. They can be, processing the warrant that was issued before this day, but they can also be tenant holding over complaints where the lease has expired, and breach of lease complaints where there's, some sort of violation, whether it's a rent violation or some other violation of the lease. Those sorts of evictions can happen right now. And so Maryland Legal Aid, again, was contacted by the county because the county has recognized that not just financial assistance needs to be provided, but legal support and assistance, because folks aren't just paying bills. There are other consequences that are going to flow from their loss of income and, being impacted by COVID. And so Maryland Legal Aid has developed a program where we will not just have our normal intake in our office, whether it's in person or on the phone available to folks, but we are going to be in the district courthouse on Thursdays for the afternoon docket, which is where the landlord-tenant cases are heard, to take folks through intake and assist and represent folks as they are responding to this. Because, I think we all understand the seriousness of the COVID-19 virus, but adding a, threat of homelessness and eviction on top of that is catastrophic. And the fact that these, was put on hold for many months, but those holds are now gone, and so there needs to be there needs to be legal support and legal information to those folks who are directly impacted. And Maryland Legal Aid is happy that the county has recognized that, and we were contacted and working with all of the partners in the community to provide those services. The other issues that we obviously know they're coming are debt collection. And so while it's not, as catastrophic as an eviction, certainly having to deal with these sorts of barriers and judgments and having folks having to rebuild and move forward once hopefully this crisis is resolved, if we can work with folks so that they understand what their rights are and work out these processes before folks have judgment upon judgment sort of just piled up waiting for them whenever everyone's back to normal. That's another service that Maryland Legal Aid and other partners in the community, legal community, are going to support with. And then continued assistance with helping folks understand the public benefits sort of maze that sometimes happens, whether it's food stamps or unemployment insurance, sort of helping folks understand what their rights are there. So all of those pieces are going to be in the Maryland Legal Aid's provision.
So, Ms. Bitter, are your fees prorated for those individuals in the community?
So Maryland Legal Aid, the way our funding works is that if someone is eligible for our services, there are no fees, because we are an independent law firm. And so our staff is paid by the funders, and so we do not have, our clients do not pay us.
Even the court filing for the bankruptcies and other court documents, do you cover the filing fees as well?
If, so in state court, we would request a waiver, but if it's not granted, which honestly I don't think I've ever had that happen, because if I represented the court, I represent this person, they are eligible for Maryland Legal Services Corporation legal services. It's written into the rules of the Maryland courts that that person's fees are waived. But for bankruptcies, which, is a federal system, right? So we either apply for a waiver for the person, or they may have to pay, and sometimes they pay in installments.
So I'm pressing this. Hi, I'm Sandy Brown. I'm the Executive Director of Midshore Pro Bono. We are a 501c3 nonprofit legal services provider that has been providing legal services to this community for 15 years. We're based here in Easton, Maryland, and we serve the entire Eastern Shore. And thank you very much for inviting us tonight. I have with me our managing attorney, Meredith Lathbury-Gerard, who's going to talk a little bit about the front lines of what the work we've been seeing since March 12th when we went remote. But mostly I want to just say to everybody here, thank you for the opportunity to serve clients in need, because we know there will be a great need for legal services. And I am personally grateful to the leadership here of the county recognizing legal services as essential. We know that the governor did, and we were grateful to the governor when he recognized our services as essential. And we've been providing these services kind of behind the scenes for a long time. It's amazing to me how many people don't know what we do. And we do this every single day. We provide access to the legal system and legal services and direct representation and counseling to people who cannot afford legal help. Legal aid does the same thing. We work collaboratively. This is a great opportunity for us to really husband the people in together to work and have a very clear, concise message, which we hope everybody else will share to the community, because the people we are trying to reach aren't really reading the Star Democrat. The people we are trying to reach need this flyer everywhere. And we are so happy because we already have clients in the hopper that will be using this funding, that we will be able to bill you immediately so that we can get the services out to them. And yes, our services are free to the client, but there are administrative costs in providing services to this community, such as rent, which we are paying rent for an empty office space in downtown Easton right now. So there are challenges that we're all facing. So this funding is going to go directly to help Talbot County residents. So thank you very much. And I do want to give Meredith, who is boots on the ground, dealing with the clients who we are hoping to help. And our staff is all doing this remotely. And I'm going to let Meredith just give you an idea of what that looks like.
How's that? Can you hear me? Okay. First of all, I just want to applaud your leadership in providing these resources to the community. Since March 12th, Midshore Pro Bono has received over 900 requests for legal services. And about 20% of those inquiries came from Talbot County residents. So, just by those numbers alone, things are really busy. They've not really slowed down. On the ground, we are seeing a whole range of legal issues emerging, particularly the need for family law assistance as well as elder law assistance. So we're getting requests from families who've had a family member who has passed away. They might need assistance with administering the estate. We have folks who have contacted us because a child has been left behind after the parents have passed away due to COVID and they need third-party custody. We've had others contact us because they've lost employment and they're unable to pay their bills, as we were just heard from Legal Aid about that, and folks who need to file for bankruptcy. And so we've been addressing these needs in a couple of ways. First, we're providing remote access to lawyers through our legal staff and our network of over 100 volunteer attorneys. We're also providing legal and financial education to help people to avoid bankruptcy and to avoid going into mortgage foreclosure. And then this is, of course, kind of the meat of what we do, which is to provide free legal representation for clients who need attorneys to defend their rights in court. We have lawyers on staff who specialize in family law, consumer debt, housing, elder law, and immigration. And we have a network of over 100 fiercely dedicated volunteer attorneys who specialize in a wide range of civil legal issues, including foreclosure and employment issues. And those folks are providing direct representation to our clients. Just since March 16th, our volunteer attorneys have provided over 100 family law consultations, And as you probably know, there are remote parts of our community where people have a really hard time accessing lots of things, but especially legal services. And so for those clients, we provide justice on wheels. So we go to them. Just last week, we assisted a member of our community who is in the end stages of a terminal illness and helped her execute a financial power of attorney so that her family could take care of her affairs. So this is the sort of personalized service that we deliver on a daily basis. And so we're also seeking to work with our local businesses and organizations that employ low-wage workers to provide that financial and legal education about how to maintain economic stability in these difficult times. For example, we worked with Habitat for Humanity this past April to provide legal consultations for workers who were in need of expungements to help them to secure employment and housing. So Talbot County's funding through the CARES Act, it's going to really help us ensure that Talbot County residents have the legal assistance that they need. They will have access to an experienced advocate who will advocate for their rights in court, and these investments will have a lasting impact on our community. And on more than one occasion, clients have said to me that having legal representation made them feel seen in a system that otherwise deems them invisible. So we applaud your leadership, and we look forward to working in partnership with the county and legal aid moving forward. Thanks for your time tonight.
Thank you all for coming in and presenting to us. We certainly appreciate all that you are doing for the community and providing your services. And having you here as part of the CARES Act, and Ms. Lane, I don't know whether you want to add anything additional to what's already been said, but you're welcome to do so. But we're not trying to make the landlord out to be the enemy here, or the bad guy, or the bad woman. But we want to make sure that those citizens who are indigent and who need those services can come to us and through our CARES program get whatever funding that you all would need to assist them. So that's why we're trying to ring this bell. It's not to put them against us. It's to make sure that those people who may need legal representation can come out of the woodwork and out of the closets and come into your offices and know that through the CARES funding that the county is providing, they can get that help that they needed. So this is not a them against us kind of thing. I know a lot of landlords right now are suffering as well because they're not getting rent, so they have bills to pay too. So we certainly don't want anyone to hear this or hear your presentation and say, here they go again. We're not being anti-business. We're just trying to be pro-help. Okay.
I just want to add my thanks that I'm grateful that we have these resources, that we have you already in the community, already doing these things at a time of need like this, where the need is just amped up. And for you and for Ms. Webb, clearly you have now some supplemental streams of funding to make these programs to meet the increased need. And do you have the tools and the capacity to get these to the folks who most need them now?
So as I mentioned, we have attorneys on staff who are ready to deliver these legal services. And, you know, I think really a part of this is a matter of helping people know that this resource is available. So, you know, our organizations are really good at reaching the folks who regularly are utilizing community services. The people we need to reach now are the folks who have not needed those resources before. They're newly unemployed. They're newly in an economic situation they've never faced before. So those are the folks that we're really trying to get out to now.
Ms. Lane, do you care to come up and be heard? I know you and Ms. Webb have basically led the charge here as far as our CARES individual assistance program. We certainly want to give you an opportunity to be heard. Again, the county received this money from the state. We want to thank the Hogan administration via the federal government for this money coming down to the 24 jurisdictions. And we want to make sure that this money gets into the hands of individuals who need it. On the business side, while Ms. Lane is coming forward, we also did receive 1.2 million. Mr. Hollis, I'm looking at you, 1.2 million. 1.2 million on the business side as well, and I think we've already handed out some $600,000 of the business grants. So we've already done half of what we had for our CARES business dollars. As Ms. Webb pointed out, on the individual side, we're right about 40,000. So, and we have to spend this money by December 30th. So I don't know why they didn't give us the extra 1 day. It's 31 days in December, but they cut us short by 1 day. So there goes the state for you. But so to the individuals out there, we have legal aid, we have Midshore Pro Bono, we have money for you to come and get. Please come get it and get the help that you need. And Ms. Lane, I'll turn it over to you.
Okay. I just want to point out that on the business side, we've actually approved grants for $797,000. So $800,000 basically is out the door, or almost out the door, to businesses. The individuals, we haven't seen as much of a response as we had expected, and this is part of why we brought everyone into this meeting, is to get the word out, because as it was mentioned this evening, a lot of the people who need help are people who aren't used to needing help. You know, these are people who've always been employed, who never thought they would not be able to make a mortgage payment, not be able to make their rent payments, and don't really know where to go. But we do have funds available to assist them with rent, mortgage, legal issues, whether it's consumer debt or some other legal assistance. You know, the county's entered into contracts with Midshore Pro Bono and Maryland Legal Aid to help individuals who aren't used to needing the help. So that's the goal of this evening's presentation, is to get the word out to more individuals who have never thought about needing help, that we do have resources available, and we hope they will take advantage of them, because if they don't, we will turn the money back into the federal government at the end of December, and that's not our goal. Our goal is to help our citizens. Thank you.
Anyone else? Okay. Linda, Angela, thank you very much for putting the presentation together. Ms. Bitter, Ms. Brown, Mr. Rod, thank you all so much, and thanks for partnering with us. Again, this information will be on the county's website for any citizens who would need the help. Again, you can go into the Department of Social, well, you can't get into the building, but you can call the Department of Social Services and get an application through them. You can also go down here on Port Street and see Ms. Marilyn Neal and the Neighborhood Service Center, and also go to St. Vincent de Paul, which is another of our satellite entry points for the program. So a number of ways we're trying to get this help to the citizens, and we're saying to you, please come, and we're here to help you. Okay? Ladies, thank you very much, and have a pleasant day, and be safe going home. I did want to add to our listening public and also to persons here, Ms. Price is with us by phone. You may hear her voice echoing in. Don't worry, she's not haunting the room. She's actually with us by phone. Okay, Council. Next on your, I'm going to hit this button. Next on your agenda is Resolution 290. Madam Secretary, would you please read the title of the resolution?
Resolution number 290, a resolution prohibiting statues depicting persons, signs, or symbols associated with military action on Talbot County property and providing for the removal of the Talbot Boys statue while retaining the base of the monument.
Thank you, Madam Secretary. At our last meeting, I believe there was an amendment that was introduced by Mr. Lesher, Amendment 1. That has been introduced, and Council should have a copy of that. My understanding this evening that there are 2 additional amendments for introduction, and I will hear from the drafter on Amendment 1, Amendment 2, and Amendment 3 at this time.
Thank you, Mr. Pack. At our June 23rd council meeting, when you and I introduced this resolution, I declared my intention to offer an amendment for the complete removal of the monument. At our July 28th meeting, I offered that as Amendment 1, and in the name of transparency, I took the unusual step of asking the staff to post it on the council website under pending legislation before its introduction. I have heard the concerns of some members of the public that the resolution did not speak about the fate of the monument if removed. In response, I have done the same with this second amendment, having the staff post it on the council website in advance of its introduction this evening. It is a simple amendment incorporating all of the language from Amendment 1. So if we adopt this, we don't need to act on Amendment 1. And adding 4, storage of monument pending relocation. The monument shall be safely stored in the care of the county until a place for its ultimate relocation can be identified and prepared. And I offer this amendment now. Likewise, I have heard from members of the public who offered to pay for the removal of this monument, at least in part. Amendment 3, which I offer now, and which has, for the sake of transparency, been posted on the county's website in advance of its introduction this evening, incorporates all of Amendment 1 and adds establishment of fund for private donations. The County Finance Office is hereby directed to create a restricted fund to receive any private contributions that may be received to offset a portion of the county's cost of removing the monument from the courthouse grounds. And the county is hereby authorized to accept such private donations for said purpose. This Amendment 3 and Amendment 2 are not mutually exclusive. If we adopt both, we simply need to renumber the paragraphs such that one becomes paragraph 4 and the other paragraph 5.
Thank you, Mr. Lesher. And as you said before, Amendment 1 has already been introduced, and Amendment 1 did strike the first whereas clause dealing with the death of George Floyd back on May the 25th. The First Amendment also cleaned up some language dealing with the body of the resolution, talking about the prohibition of the depiction of persons, signs, or symbols associated with military action. And that was done so because we did not want to, or at least I did not want to, confuse anyone with any other military monuments on the courthouse grounds, via the Vietnam Monument and the soon-to-come KIA Monument for World War I, World War II, and Korea War veterans. We certainly did not want anything to interrupt those monuments being placed, or those monuments which are already there dealing with Vietnam vets or veterans of a foreign war. So that language was cleaned up as well, as you said, in the removal of the entire statue and base was also included in that First Amendment. So, and that has already been introduced. Your Second Amendment deals with the new number 4 behind number 3, which was the draping of the monument. The new number 4 deals with the storage of the monument to be stored safely, and we want to be respectful of the monument once it comes down to make sure that it's stored safely. So that'll be a new number 4. And then your amendment number 3, if introduced also this evening, will deal with setting up of a separate fund for the establishment of monies. There were persons who said that they would pay for the removal. So if they are so inclined, that fund would allow them to do that and be set up to do that. So just want to make sure that Council have all of those in order and know what's before it. Amendment number 1 has already been introduced, so we don't need to deal with that. The Chair would first entertain a motion for introduction of the Chair would first entertain a motion to deal with Amendment number 2, which is the storage of the monument. That's your new number 4. You'll see that on page 2 of the of the resolution. So the Chair would just ask for a show of hands for the introduction of the Second Amendment by Mr. Lesher and myself. Ms. Price, are you introducing the Second Amendment?
She fell off the line about a minute ago.
Okay, maybe she'll come back on. And now we have the Third Amendment as well for consideration, Amendment number 3. This deals again with the establishment of a private fund for monies to be collected into for the removal of the statue and I guess a replacement once it goes to its next destination. And the Chair will entertain a show of hands for introduction of Amendment number 3 at this time by Mr. Lesher and Mr. DeVillio and myself. So
3 is encompassing of 2 as well. Is that correct?
3 is mutually exclusive of 2.
It is not, but it is not mutually exclusive.
Okay.
You say it is not.
They both incorporate Amendment 1.
He's
But
a-
2 and 3 are separate amendments, and one does not incorporate the other.
Okay.
Right, which I thought was his question.
I'm sorry.
You got to push the button.
To clarify, yes, so 2 and 3, each of those new amendments incorporate the
One.
old Amendment 1, but they do not duplicate each other. Neither one incorporates the other. So if we want both of those provisions, we need to vote for
Separately.
each of those amendments separately.
Mr. Beck, I've asked Ms. Price to confirm she's back on again. She was having trouble reconnecting.
I'm here.
Okay, so let's go back. We have read amendment number 2 and 3 on Resolution 290. You should have those amendments in your packet. So amendment number 2, I'm asking for a show of hands for introduction of that amendment. Are you introducing that amendment number 2?
I am not introducing either.
Okay. You said either?
Neither one.
Okay, so I don't need to go with number 3. Okay, so both amendment number 2 and number 3 have been introduced, and amendment number 1 was introduced last week. So the Chair would not entertain any discussion on any of the amendments at this time before I call for a vote on each of the amendments.
Mr. Pack, I would suggest that we skip over Amendment 1 for now, because it will become moot if we add either or both Amendment 2 and Amendment 3. So if we can just proceed to 2 and skip over 1 at this point in time.
I think procedurally, Mr. Lesher, since Amendment 1 has already been introduced, it either needs to be voted down or it needs to be withdrawn. Mr. Cooper Smith, I'm looking at your left ear just to make sure that I'm following the right procedure. Since both Amendment 2 and Amendment 3 incorporate Amendment 1, which I understand what Mr. Lesher is going with, and I agree with him, but procedurally, since Amendment 1 has been introduced, does it need to be voted down? Can I just table Amendment 1 and proceed with Amendment 2 and 3? I just want to make sure we handle this appropriately.
I think you're correct that if it's included in the other amendments, then Mr. Lesher, as the sponsor, could withdraw it. And since the others have been introduced, those are now on the table. And I assume there would be no objection to his withdrawing.
Okay, so Mr. Lesher, procedurally then.
With that, I will withdraw Amendment 1.
Okay, is there any objection to Mr. Lesher's withdrawal of Amendment number 1 to Resolution 290? Again, for clarification, both Amendment 2 and Amendment 3 incorporate the same language that was in Amendment 1, so it's rather redundant. So he's asking for that to be withdrawn. Is there any objection to it? Hearing none, Amendment 1, Madam Secretary, is now withdrawn from the Council's agenda this evening. Any additional comment or conversation on Amendment 2 or 3 for clarification before the Chair calls for a vote on those 2 amendments?
Yes, Mr. Pack,
I hear you.
because we have had no see if I can turn off my speaker. Because we have had no public input on amendments 2 or 3, I believe that that is inappropriate for us to take any votes on the amendments this evening. And additionally, the entire resolution should not have been introduced under our emergency order. We were only supposed to deal with critical legislation and the budget at this time. As an example, we let several pieces of legislation expire, including short-term rentals that's also supposed to be voted on this evening. Certainly, this is a worthy issue to be given its proper attention, but it is not appropriate to vote on tonight when we still lack sufficient public comment, knowledge of the cost of any removal, approval of the Historic District Commission, which is not yet brought up this evening, and knowledge of where and how the statue would be stored. So because we have not had that feedback from the public, and I believe this resolution was introduced at a time that was deemed only critical to county operations and the budget, I believe that we should not vote on anything this evening, but especially the amendments which have had no public input at all.
Understood. Bills have been voted on from the floor, as amendments have been introduced from the floor on bills previously without additional public hearing, as you very well know. These amendments were deemed by the Office of Law as not being substantive. Therefore, there was no legal responsibility to re-advertise and repost Resolution 290. The amendments, again, were not deemed as substantive to the overall bill. Regarding any action before the Eastern Historic Commission, unless 290 is passed, we have nothing to approach the Historical Commission with. So that's very, very premature. I know that's out in the airwaves and out on social media about have we gotten permission from the Historical Commission. But until we have something to approach to go on their agenda with, there's no need to request an audience before them. In response to that, I think it's premature to even bring that into the discussion this evening.
I would disagree as far as the appearance of being substantive. This is not your ordinary piece of legislation, and considering that we have changed from not removing more monuments and just a statue to the base, that is a complete and total change, and that we need to be above board and completely transparent with the public. And from what, I think most of us have been hearing, that they are very upset that they have not had ample opportunity to participate. We've had a lot of issues with our meetings, even though we've given our, reasonable effort, but public has not been able to listen in. We are actually dealing with an open meetings complaint right now because people were not able to participate and listen and view the most recent, especially public hearings and meetings. And there's no perfect solution for technology, but it certainly, arguably, we should wait until such time that we can host public meetings that are going to allow full participation and that we're not potentially in violation of the Open Meetings Act, which could negate the vote altogether. Technically, they may not be substantive, but I believe they are, and I believe the public feels that these are substantive changes.
Well, I'm sure there is a minority that feels that way as far as, but as far as from our legal, our Office of Law is telling us, is that these changes are not substantive, so we're going to have to go on his legal interpretation of that.
Mr. Pack, I do just want to clarify that the bar for substantive amendment is high, but if there is any concern, then out of an abundance of caution to deal with that issue, the council could, if the resolution is amended, could have another public hearing on it to eliminate any concern about that. So just for the record.
You're absolutely correct. Anything further?
Yes. I would.
Yes.
I really think that under the circumstances, I really think this is such a public event, and there's a lot of people out there that really would love to probably just hearing these for the first time. And we don't know that, so we need to give them the right to think it through to see if that's right for them. So I'd like to push it down the road a little bit, so that people can put their thoughts together. Do they like these amendments? So, and it is tough running these meetings with nobody here. I think it's going to be going down the road for the next several months. We don't know when we're going to get back to normal, but this is a big deal for a lot of people, and it's a big deal for us to make such a historical decision on something that is 150 years old. I mean, we're changing the way we're looking at history, and I think we better really take a couple steps back and make sure we're doing the right thing. And at this time, I don't think we're doing the right thing.
Okay. Certainly understood, Mr. Callahan. Thank you for sharing. My take on the amendments are this. The amendments 1, 2, and 3. Amendment number 1 has been in the public domain for more than 2 weeks. Amendment number 1 was before the public when we had the public hearing on the resolution 290, I'm sorry. So that amendment dealing with the removal of the statue and the base was there in the public domain when we had the public hearing. So to say that the public did not have an opportunity to weigh in on that is not true. They did. It was in the public domain when we had the public hearing. We extended the public hearing for written comment even up until the Friday before. So they had ample opportunity to even write us on that amendment. So that's not true to say the public did not have ample time to hear amendment number 1. They certainly did. Amendment number 2 and amendment number 3 only establishes 2 things. It talks about the creating of the statue and the storage of the statue. It talks about a setting up of a dedicated fund to receive monies. That's all it does. So another public hearing to talk about the storage of the statue and the setting up of a fund, we can, but I think that you're holding a public hearing for 2 non-substantive matters on the resolution.
I think these 2 supplement matters are huge.
I'm sorry, I can hear.
Are huge. We're not talking about Amendment 1. We know about Amendment 1, like you were saying. Everybody's heard that, but not everybody's heard 2 and 3. So I want to make myself clear on that.
Mr. Lesher,
What I would also say on 2 and 3 is on the one about storage. If the statue is simply removed, there will never be a statue that represents a very complex period in the county's history. The amendment that's being offered guarantees nothing other than it'll be stuck in storage with no defined purpose, probably forever. If people haven't come together with any effort over the past 5 years, it surely isn't going to happen once it's gone. And as far as the funding of it, we have no idea how much it's going to cost. And this amendment has 0 teeth. If there is a decision to change the monument in some way, then no taxpayer dollars should be used. And I've had this conversation with council members who are introducing. The amendment being offered tonight does not accomplish that. We need adequate time to make sure a private fund is fully available if and when a decision is made. And let me tell you one thing. if that statute is gone, nobody's going to give us any money after the fact. So we need to know how much it's going to cost and have the funds in hand if and when a change in some way is made to that monument.
Mr. Lesher, I hear from you now.
Yeah, Mr. Pack, Amendment 1, and the bulk of the substance of Amendment 2 and Amendment 3 is what came from Amendment 1. We have had that idea of changing from simply removing the statue atop the monument to removing the entire monument is something that has the public has called for. We have over, I believe, 150 comments from the public asking us to clarify that the entire monument be removed, not merely the statue. And Amendment 1 I introduced really in reaction to that public sentiment and following on my commitment from way back on June 23rd. I think that substance has been adequately vetted by the public, and it certainly was in the domain of the public hearing. So both the spoken comments and the written comments on this addressed the removal of the entire monument. Now these minor details, these smaller details, which I would suggest are less substantive, having to do with the safe storage, the assurance that this will not be destroyed, and the one that we could already probably have solicited contributions for this, but this simply makes that explicit. Again, it doesn't really change the fundamental nature of the legislation here. And so I would submit that the real change was what was introduced prior to the public hearing 2 weeks ago in Amendment 1, which is now fully incorporated into both of these new amendments. Those ideas truly have been vetted in the formal process of our hearing and our written comment, and in the informal process of local media and social media. These have been widely discussed, and I think that we have wide public input on these matters.
Okay, thank you, Mr. Lesher. So we're going to be moving Amendment number 1 off to, well, that has been withdrawn, and moving forward with Amendment 2 and Amendment 3. So I'm going to be calling first to vote on Amendment number 2 to incorporate Amendment number 2 into Bill 290. This is just to add Amendment number 2 into the bill for 290. That's what this is for, to add Amendment number 2 into the bill, into the resolution of 290. So, Madam Secretary, on Amendment number 2 to be incorporated into the resolution, please call your vote on Amendment number 2.
Sorry,
Yeah.
Mr. Pack, we need a motion and a second.
I will move Amendment number 2.
I wrote down Mr.
I believe we had introduction, but not a motion.
Right. So to vote on Amendment number 2 to introduce, Mr. Lesher is making the motion. Is there a second?
I'll second it.
Amendment number 2 is seconded by Mr. DeVillio. Any further discussion on Amendment number 2? Hearing none, Madam Secretary, now for the vote on Amendment number 2 to be incorporated, please call your roll.
Mr. Pack?
Aye.
Mr. DeVillio?
Abstain.
Mr. Callahan?
No.
Mr. Lesher? Ms. Price?
Abstain.
So amendment number 2 does not pass, so amendment number 2 is not going to be incorporated into the bill. Now, the chair will entertain a motion on amendment number 3, and this is dealing with the actual storage of the monument.
Mr. Pack, I will move for amendment number 3.
Motion is made by Mr. Lesher on amendment number 3. Is there a second?
The private funding, is it not?
Number 3 is the private funding, you're right. Pass my gavel over to Mr. Callahan, and I will second amendment number 3. This is dealing with the setting of the private funding for the statue, so it'll be seconded by Mr. Pack. Any further discussion on amendment number 3?
Madam Secretary, can you call the roll call?
Mr. Callahan?
No.
Mr. DeVillio?
No.
Mr. Pack?
Aye.
Mr. Lesher? Ms. Price?
No.
So amendment number 3 fails, still also dealing with the establishment of the fund. So now we have Resolution 290 before us as originally drafted. And with amendment number 1 being withdrawn, it has the language, the first whereas clause is still back in there, as well as the language dealing with the depiction of signs and symbols of military persons, which we wanted to be removed. So I will open up any discussion on amendment number 1. Again, I know it has been withdrawn, but with amendment number 2 and amendment number 3 failing, you basically have the amendment back before council as originally drafted without those amendments being added to the changes to the language.
So I'll begin with comments on this. I fought back and forth on this several times. We've worked through many amendments. My problems with the amendments is the timing of right now with COVID-19. I'm absolutely committed to this goal, and I'm committed to being fair and transparent. This piece of legislation has been brought in front of the public at a time when we've not been able to open up to the public as we have in the past. We've battled technical issues, closed rooms to the public, and are in a financial freeze due to COVID-19. We've also joked earlier that every single meeting has been run differently through technology because we've done everything in our power to change and improve all of the public hearings that we've been having. It's in my opinion that our attempt has failed to be anywhere close to the quality of the hearings that we've held in the past. I'm committed to move forward with a plan, a committee, and a ballot question so that we can put this issue to rest with a full public input at the nearest possible election.
Thank you, Mr. Villio. Anything further?
Yes, I would like to follow up with Mr. DeVillio's comments. I've thought very, very hard in the last couple of months, too. I think there's been some decision-making that hasn't been the best. I feel like this isn't the most appropriate time to bring up something like this in a pandemic and put staff, put public, put all our safety people in sort of a way that we've got to be protected. There's a lot of moving parts that this isn't the time to be voting on this. The bigger thing that I've been thinking about is, like Mr. DeVillio said, I think that this should be in the hands of the community and not our hands. This should be something that should be voted on from the community. People have asked me many, many times, can you put it on the ballot? We all know we can't do that this go around. We'd have to do it in '22. So I think council really should give that some really hard thought to be doing that. It's only fair that the community make that decision, not us. I feel very uncomfortable with something that's happened, 155 years ago, and I'm making a decision on whether this thing should go or not. I don't think that's fair. I don't think that should be my decision. I don't think it should be the council's decision. I think it's the community that should be making that, because it's been there. We've gone over this 5 years ago. Mr. Pack, you did a great speech. We had the community there. We had everybody. We set a plan. We said that, if you could get a plan together and come in front of us, we could take a look at it, and we can put a union statue right beside that one. We went all through that. And a prime example is the ladies that come in front of us a couple years ago with the Korean War monument. They did their homework. They've gone in front of us many times, and we have approved them to come in the courtyard to put their monument. That's the way we should be doing it.
Okay. Well, I know the way this vote is going. I'm going to call the vote in just a moment. But just my closing comments to your comment, Mr. Callahan. I can't count on my fingers the number of times you have said that the people of this county elected you to make decisions. And you have said it repeatedly on a number of occasions that they have elected you to make decisions. This is a decision that you have to make. You can't now throw it back on the people and say it should be the people's decision. And yes, let's be transparent. I initially wanted this to be a ballot question myself. I'm not saying that I did not, but once I knew that that avenue was closed, you remembered me saying, I am glad that that avenue was closed because I felt that the decision that I should be making as an elected official. So you can't go back and forth to say that one day they hired you to do a job and you're here to do the job and entrust it, and now say that I'm going to throw it back on the people. That's not really fair. So that if it's a thing that you don't want to vote for the statute, I understand that. But look, this is a very.
No, we need to stop that. You're putting words into his mouth.
I'm not.
And mine as well.
Let him
Mr.
say what he needs to say, and I'll comment on that. Let him say what he needs to say.
I haven't brought you up at all. So I don't know how you say I'm putting words in your mouth. I have not brought you up in the least. I was speaking to what Mr. Callahan has said previously regarding his position. So I haven't brought you up, so I don't know why you started putting words in your mouth. This is a monumentous decision, whether it's done during the time of a pandemic or whether it's during time of not a pandemic. It speaks volumes to what this county is saying about itself and its reputation. We can't say that because of a pandemic we cannot conduct business. We conducted business whether we were up on Chesapeake, the community center, and now we're conducting business here. The business of the county has never stopped. The business of the county has never stopped. We may have been closed to the public, but the business of Talbot County has never stopped. Not one day.
I didn't say it stopped. Okay, Mr. Pack, I did not say that. And look, let's go back 5 years ago, okay? We're dealing with your change right now. You've done flip-flopped 180 degrees. So we're dealing with that as a council. So if I feel like, it's the wrong time and we need the public to vote on this, that's what I think. So don't tell me that I'm this and I'm that, and I should vote on it because the public.
I'm not saying that at all, Mr. Callahan. I did not say that. I'm not putting words in my mouth. Go back and look at the tape. I'm not putting words in your mouth. You have said repeatedly that the public has put you here to make decisions. That's all I said.
Well, what's wrong with that?
Absolutely nothing.
But it's okay for me to say that I think in this incident it should be in the community's hands, not mine. What's wrong with saying that?
I'm just saying if that's the way you feel, Mr. Callahan, then there's nothing wrong if that's the way you feel. All I was alluding to is that in the past, you have said
I
that they
have that. I've said that many times.
That's all
I've
I
said that many times.
Well, what's the argument? That's all I said.
But the argument is, this is something that's 155 years old.
It's
okay?
it's not 155 years old. It was erected in 1916.
No, we're talking
it's
history.
not 150 years old.
We're talking history here. That's what we're talking.
Yes, but the statue is not 150 years old. It was
okay,
erected
it's
in
106.
1916.
It's 106. It's older than us. That's for sure. And nobody's here that's on that statue. There's 84 names on that statue, and they can't stand in front of us and tell us what their thoughts are. So that's something you need to think about, too.
Okay. Now, Mr. Vilio, you were saying before?
That my decision, I've gone on the record and offered up an idea with a plan and forming a group and forming the money to do it. It was a simple one-page resolution, and unfortunately, it did fall at the wrong time. You just said that. The county has been open, but not to the public. This room has not been open to the public. The libraries have not been open to the public, where many people get their information. We just received a grant to extend broadband throughout the county. We know that not everybody has internet access. We know that there's lots of people that would fill a room for a typical hearing. That did not happen. In my opinion, the county council did a great job with the past hearings that they've done. We've exhausted our resources. Now it's time for us to put it back to the community. If they've asked 3 different councils to change their opinion, and we've tried, we're putting it back to the community to put it on a ballot question would be my plan, so that everybody has that opportunity to voice their opinion.
Mr. Peck.
Yes.
The timing of this on our agenda was not yours. It was not mine. It was the public. It was the public that asked for this. And perhaps the public didn't take into consideration the challenges that we would have with COVID restrictions, but here we are. It doesn't look like this is going to is going to pass tonight, and I want to thank the very many people who have expressed their opinions about this in person, in writing, by showing up on the courthouse square. The removal of this monument would not change the history of this county, and it may not directly improve anyone's economic or physical well-being. But the number who've expressed their feelings in this matter have made it clear that this is indeed a powerful symbol. And our actions on it tonight, I'm afraid, sadly speak of who we are now as a county and the extent to which we have not yet changed. I aspire to be better than this. Our failure to act to remove this monument from the courthouse square, in our failure to do so, Talbot County increasingly puts its tourism economy at risk, along with our legendary reputation for hospitality. Whatever it may have meant in the past, the Talbot Boys today is not viewed as a welcoming symbol. That we accommodate all people here with equity and with justice. Now, more than ever, if Talbot County's economy is to recover from the devastating impacts of COVID-19 pandemic, I fear that we further imperil it by allowing us to remain the last holdout of a Confederate monument on public property outside of a battlefield or cemetery in the state of Maryland. As Mayor Mitch Landrieu of New Orleans put it, to literally put the Confederacy on a pedestal in our most prominent places of honor is an inaccurate recitation of our full past. It is an affront to our present, and it is a bad prescription for our future. History cannot be changed. It cannot be moved like a statue. What is done is done. Surely we are far enough removed from that dark time to acknowledge that the cause of the Confederacy was wrong. And in the second decade of the 21st century, asking African Americans or anyone else to drive by this property that they as members of the public own, occupied by reverential statues and names of men who fought to destroy the country and deny that person's humanity, seems perverse and absurd. Centuries-old wounds are still raw because they never healed right in the first place. We are better together than we are apart. It's a much longer speech, and I gave you just a small piece of that, but it does seem to apply to our situation here today in Talbot County.
Thank you, Mr. Lesher. I don't have anything prepared other than to say that I am saddened as well to see that it appears that the vote would not be to remove the statue and to set up a way to fund its removal, and also to make sure that it is properly stored until a site can be selected for its new home, which I thought was a very eloquent way of you handling that. And I want to applaud you for all your efforts to make sure that if removed, it will be done so appropriately and it would be funded with either private and public money. It appears that that's not going to happen this evening. I agree with what you're saying. I think that the tourism and also maybe even the restaurant industry here in Talbot County, especially here in the Eastern, may take a hit because of this. Where I was 5 years ago is not where I am today. People change, times change, and I've said repeatedly, a man who fails to change his mind will never change the world that's around him. I have changed, Mr. Callahan, from where I was before. I do not support the Talbot Boy statue remaining on the courthouse lawn. I don't think it's appropriate. I know what I said in the past. I'm very much aware of what I said in the past. But it's not appropriate to keep that symbol on the courthouse lawn. I've made my apologies to myself. I've made my apologies to persons previously because of my vote in the past. It's not one of my better votes, and I'm ashamed to have voted that way. But that's done. That's in the past. We can only look to the future and only make those changes today, which will impact our future. I think that not removing that statue will certainly say a lot about this county, a lot about this council as we move forward through the rest of this term and into the next. So it is very unfortunate. I would not be voting for a ballot question. It is responsibility of the elected officials to make this change and not hide behind it. I know what I said in the past about wanting it to be on the ballot. I did look at that. I was probably the first one who said that, but I was glad when it turned out that we could not do that. So fortune basically fell into my lap on that one because it is a decision that should be made by the elected body. So with that being said, again, I do also want to thank all those who called in, who wrote to us, either way, either for it or against it. Thank you for your time that you spent in doing that. We did the best that we were able to do with the technology. Thank you to Parker Durham, our IT director, and also the Avalon, as well as the Bones phones. I know I'm saying that wrong. For all of their work in getting the technology and the software together so that we could communicate with callers. This is our new reality, gentlemen. We can't bring people into a room. We can't hold mass public hearings. This is the new reality. We have to conduct business as best we can. We may be this way for the end of this term and into the next year. So we can't keep on saying we need to have 100 people in a room. We're not going to get there. We're not going to get there. We're not. So we either have to realize where we are and do the best with the technology at hand. With that being said, if there's no further comment, as now introduced, the chair will call the vote on 290, Resolution 290. Madam Secretary, please call your roll.
Is this moved to a final reader? Has this been moved to a third reader?
It is eligible for vote tonight. It is a resolution, so it has been read already by Madam Secretary for a second time.
That's correct. An ordinance would go to third reader.
Anything further, Mr. Lesher?
It's a resolution, so it has no time frame, unlike an ordinance.
But I don't think Mr. Lesher extending this or postponing this. You did a yeoman's job at what you've done with your amendments. I think you considered what you were hearing from your fellow council members, what you were hearing from the public. I don't want to belabor this point. I don't want to belabor the public and the media any further with this. You've done your best. You've done your best, sir. And I think at this point, let's go ahead and call the roll and move on. Madam Secretary, please call your roll on Resolution 290 as drafted.
Mr. Pack?
Aye.
Mr. DeVillio?
No.
Mr. Callahan?
No.
Mr. Lesher?
Aye.
Ms. Price?
No.
Resolution 290 fails. Madam Secretary, next on the agenda, we have Bill 1446.
Bill number 1446, a bill to amend Chapter 190 of the Talbot County Code, zoning, subdivision, and land development to improve and clarify the processes for licensure and oversight of short-term rentals in the county, and to amend the standards for safety for licensure.
I can take the lead on this.
Okay, you have to press
Mr.
that button.
President.
Please speak right into the mic.
Sure. Mr. President, members of the council, if you would like me to do that, I can walk through the components of what is in the legislation, and also I can walk the council through the matrix.
One moment, Mr. Salinas. That's okay.
If you would not like me to do that, we stand for questions on any part of the legislation that you have questions on.
Any questions of Mr. Salinas or any other member before council on 1446?
My question I had was, I'm trying to find which page. So it's page 8 for us under G, hearing and decision. All owners of properties, the 1,000 feet and the 500 feet, we discussed that, and I was wondering if you could give us just a little bit of background on who came up with which on those.
Sure. That came up, and I believe that came up during the workshops that the Short-Term Rental Review Board held in August and September of last year. We received comments from the public that in some of the more dense residential districts, relative to the other conservation districts, that the 1,000 feet was onerous and costly. For example, a property in Tillman that had the 1,000-foot radius could generate letters in anywhere from $500 or I'm sorry, 50 letters to 100 letters. And so that they were spending upwards up to $1,000 in certified mailings for those. And so the suggestion was for those residential zoning districts to reduce that from 1,000 to 500 feet, and they would still target a number of properties, anywhere from 20 to 50 properties at that distance. And so that was discussed when the county council held their joint work sessions with the short-term rental review board, and that was approved by under the straw poll voting. That was voted on 5-0 by the county council. That would be on page 9 of the matrix.
Thank you.
Could I just make one comment on that, maybe better? When we took that straw poll vote, we had not decided on going down to one mailing, which cuts the costs in half. So I would like to have this under consideration, because in the dense areas, it was still, I might tend to agree, but now that we're looking at going down to just one mailing, I think we ought to take consideration to maintaining it at 1,000 feet.
Laura, nobody could understand any of that.
Try again. Can you hear me now?
Yes.
Okay. When we took the straw poll vote, are you hearing me?
Yes.
When we took the straw poll vote on going from 1,000 feet to 500 feet, there were still 2 mailings required by certified mail. Now that we're considering one mailing with just delivery confirmation, the cost will go down significantly.
Okay, are there any other questions of Mr. Salinas or Mike on 1446?
Just, sorry, one more thing. And I'm trying to find it. The carbon monoxide detectors that are being, what's the term? Connected or interconnected?
Interconnected.
Yes. So I did a little bit of research on those. I've had some people emailing in and questioning about that. So those, I just would like to confirm with you guys, those are interconnected by a radio frequency amongst themselves. The customer does not, or the homeowner would not need to have a Wi-Fi or anything. Those devices work amongst themselves. Is that correct?
That is correct. They work amongst themselves.
Thank you.
So I'm just making myself clear. If they work by themselves, you don't need internet service, you don't need Wi-Fi, you don't need none of that. So they work independently through their little, if you got 4 or 5 or 6 of them, they work together.
Just like the smoke detectors, they work independently. You don't need a Wi-Fi or anything else. There are certain ones that are available with a Wi-Fi and through your computer, but the ones that are most common are independent of and do not need a Wi-Fi or anything else.
Gotcha. Thank you.
My button. Any further questions? Stay put right there. On amendment, on Bill 1446, we had one amendment which was already introduced, I believe, Madam Secretary. And this amendment did, I believe, deal with the carbon monoxide detectors being installed. And I believe that first amendment has already been introduced, so I'll bypass that.
All 3 amendments have been introduced.
All 3 amendments have been introduced? Madam Secretary, I don't have Amendment 2 in front of me. I'm sorry, I can probably.
That is the 3-night minimum down to 2-night minimum.
Does anyone need any explanation on Amendment 1 before I'll call the vote for the add Amendment number 1 and 2, Bill 1446?
Could you briefly say what Amendment 1, 2, and 3 do for clarification?
Sure. Amendment number 1 deals with the interconnected carbon monoxide alarms to be installed in fuel fire appliances are present, or a unit has an attached garage. The alarm shall be installed outside of each separate sleeping area in the immediate vicinity of the bedrooms where a fuel burning appliance is located within a bedroom or its attached bedroom. A carbon monoxide alarm shall be installed within a bedroom. Combination carbon monoxide alarm and smoke alarm shall be permitted in use in lieu of the carbon monoxide. So if you have a combination smoke detector, carbon monoxide, you don't have to, then that would be fine. So that's the amendment number 1. Is that sufficient? It's also in Granicus if you want to pull it up, Mrs. Price, but just for your reading, that's the amendment. There's no further questions. The chair will ask for a vote for amendment number 1 to be added to the bill. A motion by Mr. DeVillio, seconded by Mr. Lesher. Any further discussion on amendment number 1? Hearing none, Madam Secretary, on amendment number 1, please call your roll.
Hang on, Mr. Pack.
Okay.
I'm trying to understand if Amendment 1 requires the interconnectivity or does not. I'm scrolling through.
Hey, Laura, we couldn't hear you, so could you repeat that, please?
I'm not quite sure if Amendment 1 requires the interconnected carbon monoxide detector.
It does require the carbon monoxide detectors, yes. And where there's a presence of a fuel burning appliance.
So if we didn't do the interconnected, is an independent carbon monoxide detector still required?
Could you say that again, please?
If they are not interconnected as per Amendment 1, are independent carbon monoxide detectors still required?
That defeats the whole purpose of being interconnected. So the thought process, Laura, is so if you're if there's one at the appliance, so to speak, okay, and you're back in your bedroom, you need to be alerted back in your bedroom because your bedroom could be, down the hallway, and you not hear it go off at the appliance. So that the whole sort of interconnected is the concept of the safety aspect of it. And I do agree with that. I mean, it is, yes, it's an expense, and I understand that. But, speaking, from my firefighter hat, I think it's appropriate to have that, because what you really have to look at in this particular situation, you have people in that house that don't know that house. So, it's your argument, what you're saying, if you are questioning it, that'd be different if it's a homeowner. But when you have people in there that are not used to the house and not used to how it operates, you need to bring it up to safety standards.
Just trying to understand. Thank you for the explanation.
Okay, if there's nothing further on Amendment 1, it has been introduced, a motion has been made, it has been seconded, there's no further discussion. Madam Secretary, would you please call your roll on Amendment 1 to Bill 1446?
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Ms. Price, I need your vote on Amendment 1, please.
Aye.
Amendment 2 reduces from 3 nights to 2-night minimum stay for all short-term leaseholders.
Thank
Any-
you very much, Madam Secretary. Any discussion on Amendment number 2?
This was an amendment that I offered. I think it's pretty straightforward. We've received a lot of comments about the events around here are typically just short weekend events, so we were trying to make it a little bit easier for the folks who are coming.
I think Amendment 2 is probably, again, going back to the fact that you're in the middle of a pandemic, going to bring more people into the area during a time when you don't want to bring more people into the area. So I don't think that's what you want to do, is encourage shorter stays. If you're going to have a 3-night minimum against the community that STR is in, I think will benefit from a 3-night minimum. The person can always stay longer if they choose to, but a 3-night minimum at least gives the less frequency of persons moving in and out, back and forth into a community. I think right now, as we talked about before with Resolution 290, why make these type of drastic changes where you're bringing people into a community for shorter stays? This is not the appropriate time to do this. The 3-night minimum stay basically has not been on the books for more than a year. Since we introduced this, and it got a lot of feedback from the public who wanted to make sure that there was not a lot of activity in and out of these communities. So this is probably not one that we should be doing at this time for a number of reasons.
Could I amend this so that it would take effect after the governor lifts the state of emergency? Mr. Cooper-Smith?
Did you amend it?
Could I amend this so that this would take effect after the governor lifts the state of emergency?
I suppose you could, but I believe this is a definition in the ordinance, and so we wouldn't normally have, obviously we wouldn't normally have something in the zoning ordinance that's connected to that kind of an event, but technically I suppose you could do it. The other option would be just introduce legislation at that time once the governor's state of emergency ends to make this change.
I could go either way with that. I guess I'm doing my best not to pass legislation that's going to take effect and last for 20, 30 years and try to take into effect the current state of coronavirus, which we all hope to move through.
Yeah, I would agree that that seems reasonable. That, I hear you, Mr. Pack. That seems, reasonable if we could hold off until the emergency order is lifted and didn't do the 2 days. I mean, the whole concept of the 2 days is not necessarily bringing more people in here. It's actually a little bit what I'm hearing from everybody that's voiced their opinion about the 2-day thing, because it's a Friday, Saturday. situation most of the time. And, you know, when people do come for the weekend, they come mainly for 2 nights instead of 3 nights. And, you know, the outfitters in Talbot County too, they're struggling with the 3 nights. And, you know, a lot of people want to do the 2 nights, and it really seems cost effective. And when you're doing 3 nights, it's really not cost effective to stay that 3rd night. So, you know, I would like to see council, you know, be reasonable, you know, and I'm with Mr. DeVillio, that maybe this takes effect, you know, after the first of the year or something.
He can,
you know.
he can do likewise what Mr. Lesher did with his first amendment and just withdraw the amendment. He's the only person that introduced it, and just withdraw it. And, you know, as far as cost effectiveness, we don't even have any data to speak to that. But that's a very good point. Before you make this kind of a change, to kind of speak with Ms. Lane to see, has there been a decrease in STR rentals because of the 3-night minimum stay? Again, the 3-night minimum stay has only been in effect roughly a year since the changes took effect on 190. So you're making a change before you even have ample enough time to review whether or not what you did a year ago is working. So and then you don't have the fiscal data to back it up. So you're right. You know, is it cost effective or is it not cost effective? You don't have the data to even answer that question.
Well, we can look at competition and see that the surrounding areas around us have shorter limitations. And so when somebody's looking for a 2-day weekend to go away and they see that they can't stay in St. Michael's, they immediately move on and look at another place. So we're hearing it from people who manage properties in different areas as well. So it's not just Angela Lane who would have the numbers on this. So, and then you also have the people who play the games. And they're going to rent the house for 2 days and they'll charge a penny for the 3rd day or not charge anything for the 3rd night. Again, I'm open to suggestions if you think that, you know, a 2-night minimum with a certain number of options that the person could do that per month is acceptable. I know that people are concerned that they're going to be having somebody show up Monday and Tuesday and then Wednesday and Thursday and then Friday and Saturday, a lot more people. But again, in keeping with what Talbot County is, we are a weekend destination, and I'm trying to make it easier to the consumer when it's appropriate for the consumer to come here.
I would go ahead, Laura.
I was just going to say that I think this is worthy of consideration, but I would feel more comfortable if we just introduce this later and not say it's going to take effect at the end of the state of emergency.
I withdraw my amendment.
Mr. DeVillio has withdrawn amendment number 2. Any objection? Any additional comment? Hearing none, Madam Secretary, amendment number 2 to Bill 1446 has been withdrawn. We're moving on to amendment number 3. Madam Secretary, when you get a chance, please read that one.
Amendment number 3 reads, the maximum number of persons permitted to be on site associated with any short-term rental, adding during nighttime hours, sunset to sunrise, shall be limited at all times to the lesser of 12 persons or 2 persons per bedroom in the dwelling that is rented, striking primary. There shall be no limit to the maximum number of persons during daytime hours, sunrise to sunset, except to the extent that another section of the Talbot County Code or other law, regulation, rule, order, decision, or condition of approval imposes such a limit or otherwise curtails the gathering.
Thank you, Madam Secretary.
And again, this is another amendment that I've offered up from discussing things with the community and hearing about people who want to come down, rent a house for Thanksgiving. Maybe their family's coming here to visit family that's already here, and so they would like to have those family members come over because the kitchen's larger. Crab feasts are obviously very popular here. People like to rent houses on the water, and then they meet up, they take out all their paddle boards and paddle out for the rest of the day. When you look at some of the properties that we have, Obviously, if you're on 10,000 square feet and, you know, you're a quarter acre in town, 12 people is a lot. If you look at somebody like the Blair Farm, which could end up being a short-term rental on St. Michael's Road, having 12 people, you probably wouldn't get the grass cut all in one day. So what I was doing is looking at an opportunity for families to gather, which is what we look for, which is what our events are for, at a vacation property in Talbot County during the day, when it's not a party. It's obviously during the day, so if enforcement needs to take action, it's going to be much easier for them to see what's going on and know. But it, again, allows families the opportunity to explore and enjoy the Chesapeake Bay so that they go home to wherever they came from and get to talk about how nice this area is and how well it needs to be protected.
The previous council had an extensive public hearing on the maximum number of persons in an STR. And coming to the 12-person maximum was after a number of exhaustive hearings with citizens, because these neighborhoods that these STRs sit in are sometimes the homes are very close together. There's not a great deal of setback between the homes. This may work at a 10-acre lot, but this won't work on a quarter-acre lot. In allowing persons who are not registered on the lease to come onto the property, I think you're really opening yourself up for a lot of problems, a lot more phone calls, a lot more calls for Mike and for Dwayne to go out to, because things have gotten out of hand. Again, we're making changes to a particular bill that has only been around for approximately a year. And we don't have the data to back it up to say that we should change it from a 12-person on the lease maximum to an unlimited daytime activity. One person may have the proper intentions for just an evening of sitting out and barbecuing and having crabs. The next 5 people may have a whole different interpretation of what they want to do. So this is dangerous in my opinion to do something like this so soon after the bill has been drafted. And again, knowing that some of our neighborhoods, Rio Vista, are very nestled close together, I can hear the phone calls coming into you right now, Mike.
I don't see a whole lot of problem with it, and I don't see any danger with it. What I see is if there's a problem, you pull the license. That's what I see, and you see a fine. You make that judgment. That's why we've got you know, rules that you're going to apply if somebody does something wrong. And at this stage, we haven't had an issue that's come to the council with, you know, multiple people on the property. So I don't see where it's an issue.
Well, you don't
jump in if I
probably
can.
don't. Hold on a second, Ms. Park. You probably don't have that, Mr. Callahan, to the point because of what we put in place. It's working. And that's what you want to see. We put those things in place on the last council to make sure that the people that were listed on that application that had to be posted, so when Mike and Dwayne go in there, they can say Mr. Brown, Mrs. Brown, Mr. Thomas, Mrs. Thomas. Those on the application, those supposed to be on the property. And you're correct, we don't have those problems because of what the prior council did. On doing that, you will see the problems. If you're going to say it's unlimited, anyone can come on the property during the day, you will see the problems. And you haven't seen the problems because of what the council did through some foresight and listening to people and listening to our compliance officers and putting things in place to curtail that kind of activity. So you're absolutely right. We haven't seen that because of what the prior council did.
Or because of the individuals who come to this area. So again, I'm willing to discuss this and see if maybe we could have double the occupancy during the day, up to 24 people on a property. Again, Bentley Hay and Rio Vista are unique. When we're looking at the county, we have to think about the county in the whole. Some of the outlying areas with the nicer, larger properties can easily handle this without anyone ever noticing. I remember the first night of my wedding was spent at a short-term rental in Talbot County, and we rented way too big of a home on way too big of a property so nobody would know, and we really enjoyed it. And I've thoroughly enjoyed that to the point that I would like to share that experience with other family members and have them come here at the same time. I have 2 young children, and my wife has several siblings, and when we all come together, it's fun to see the children play and enjoy the Chesapeake Bay. That's what I'm looking for, and if you would want to go with double the occupancy or triple the occupancy, I would certainly be willing to listen to that.
Mr. DeVillio, I think that we can work on something again, maybe next year. This wouldn't be the time because of the pandemic. But the wording now is unlimited. So why don't we put together some other options and have a new public hearing when the time is appropriate, rather than trying to amend this on the fly tonight?
Mrs. Price, are you speaking on 2 different devices? Do you have 2 devices unmuted?
I'm not. I literally have the phone to my ear.
Mr. Pack, right now our STR regulation scheme doesn't make any distinctions between large lots and small lots, between villages like Nevitt and TR zones like Bentley Hay and Rio Vista, and truly large lots with large setbacks. I think to deal with a provision like this, we need to look at something much more comprehensive than what's before us now.
I would certainly agree with you. I mean, you do. The change from the 500 from the 1,000 feet to the 500 feet does consider those village smaller density areas than those wide open areas. So there is a distinction on that as far as notifying persons within a 500 foot to a 1,000 foot. But on something like this, again, yeah, you would have to probably do the research and kind of look at those lots, sit down, look at the map, get with Mark Calhoun, look at the GIS mapping, and kind of figure out how many lots do you have of what particular size and what you're going to allow to happen on those larger lots as opposed to the smaller lots in village centers. This doesn't do this. This opens up the Wild Wild West for everybody.
Well, it appears that I have some work cut out for me on these 2 amendments. I will go ahead and withdraw that amendment and come back and sit down with the planning staff some more to see if we can come up with, like you said, something lot size dependent.
Any objection to amendment number 3 being withdrawn? Here now, Madam Secretary, amendment number 3 to Bill 1446 has been withdrawn by the issuer. Any further discussion on Bill 1446 now as amended with amendment number 1? Hearing none, Madam Secretary, please call the roll on Bill 1446 as amended with amendment number 1.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Ms. Price, I need your vote on Bill 1446 as amended, please. Could you try to get her back online, please? We're in the middle of a vote.
She said I'll try a different phone.
Okay, Madam Secretary, please note for the record, we were trying to reconnect with Mrs. Price. She has not been able to be reached. We're going to pass Bill 1446 440 at this time. Thank you. Okay, since, so Bill 1446 passes as amended, 5-0. Okay, Bill 1446 has been passed as amended. Gentlemen, thank you very much. Anything further? Secretary, if we can move along with Resolution 281.
Resolution 281, a resolution to amend the Talbot County Comprehensive Water and Sewer Plan, the plan to reclassify and remap certain real property located in the town of Trapp, Maryland, associated with the Lakeside Plan Unit Development, the Lakeside Project, formerly known as Trapp East, further described as Tax Map 54, Parcel 304, Tax Map 55, Parcels 14, 15, 17, 19, 44, 65, 83, and 85, and Tax Map 59, Parcel 4, the total area consisting of 865 acres, more or less, the property from S2 and W2, areas where improvements or extensions to existing or construction of new community, multi-use or shared sanitary facilities are programmed for progress within 3 to 5 years, to S1 and W1, areas served or to be served by community, multi-use or shared sanitary facilities which are existing, under construction, or have immediate priority status, to amend the plan to add certain water and sewer capital projects related to the Lakeside Project and existing systems for the fiscal years 2020 through 2030, and to amend the plan to update the narrative description in the plan relative to the Lakeside Project and existing systems.
Mr. President,
I'm sorry. I was a bitty. Mr. Clark, you want to come forward to be heard before we move on the resolution?
Just keep it. At this point in time, for the council, I don't have anything to offer unless y'all have any questions or comments.
Well, this resolution does have an amendment, so there is one that is being offered up to the resolution. I'm sorry, Madam Secretary, I'm going to try to find the actual changes to the amendment. Mr. Cooper Smith, I believe the amendments to this, to Resolution 281, there's one amendment. It's dealing with the split zoning of the property.
That's correct, Mr. Pack. The main effect of Amendment 1 to Resolution 281 is to take the area of the property holding and to make it partially S1 and partially S2. The original resolution would have that entire area as S1. The town of Trapp and the developer submitted Amendment 1, which would split it into two sections. It also, the amendment also makes certain changes to the text that we could go through in detail if you'd like. But one of the key points there is that for the first phase of the development, they could draw from the existing trap sewer plant or construct their own facility. And then there are some other changes, but that was one of the key points.
Thank you. Currently, the whole entire acreage sits at S1, W1, which means that development can take place anywhere on the lot, either the Barber Road side or the 50 side. I think that the agreement that came out of the discussions with the town of Trap and also with the developer was to do the split zoning to allow the first part of that development to stay on the S1, W1 side, and then once that's developed out, to be moved over into the S1, S2, W2 side of the lot.
Mr.
Ryan,
Pack, is it currently S1, W1, or is it now S1, S2, W2?
I think right now the whole lot is S1, S1, W1.
No, Mr. Lesher's correct. The whole area is S2, W2. The resolution would make it S1, W1, all of it, and then the amendment changes that to make part of it S1, part of it S2, W1, W2.
It's split in half.
Ms. Shorter, do you wish to be heard on either the amendment or any parts of the Resolution 281?
Hold it down. Thank you very much, Mr. Pack, members of the council. Just very briefly, I just want to reiterate that what is proposed before you today, what you're being asked to adopt as an amendment, is an amendment to update your plan, which already reflects this project. It already includes a standalone wastewater treatment plant for Lakeside. It already contemplates groundwater disposal through spray irrigation of the treated wastewater. And it takes what your plan currently permits as a B&R quality plant. It imposes a requirement for E&R level treatment, which is state-of-the-art level treatment for that plant. If you don't adopt the amendment, your current plan permits that plant to be constructed today with a B&R quality plant. That's not my client's intention, and that's why we've asked for an amendment to update.
What would MDE allow at this point? Would they allow a new B&R plant of this scale?
Absolutely. And the draft permit that MDE issued in connection with the wastewater disposal application was a B&R plant. We've responded to MDE and indicated our intention to build an E&R plant and requested that they update the permitting, the discharge limits to E&R quality, but the draft permit issued by MDE with their tentative determination was for a B&R quality plant.
Any further questions, Mr. Showalter or Mr. Clark, on the resolution or the amendment? Okay, Madam Secretary, I'll call the vote on, thank you very much, Ryan. I'll call the vote on Amendment 1 to Resolution 281. I need a motion to, on Amendment 1. Moved by Mr. Callahan.
Second.
Second by Mr. Villio. Any further questions on Amendment 1? Hearing none, Madam Secretary.
Can you hear me?
Yes.
Okay. I'm uncomfortable with this being on a BNR plant and allowing more discharge into an impaired waterway. I would be far more comfortable if this was upgraded to ENR before the houses are built. As a member of the Board of Health, I believe that that is what we need to do for the health, safety, and welfare of the developer to hook up to a sewer plant that isn't substandard.
I don't believe that the wastewater treatment plant is substandard. I believe it is discharging according to as MDE permit. The levels are within that it's permitted MDE application, so I wouldn't say that the plant is substandard at all. Any further comment on amendment number 1?
I have the same work that allowing the first 120 units to have their waste diverted over in the existing trap plant. That plant has in fact violated its discharge permit conditions. It is an old, outdated plant. It is due to be upgraded. They are now in a preliminary engineering report that should be completed this year. They're in process right now. We should we should not permit this to go forward until that plant is upgraded for the link. And Amendment 1 would do that. If this could be changed such that there's a delay in this such that hookup would not happen until TREP's plant is upgraded, I could support this.
I don't think the plant as currently is facing any type of violation at this time.
They have a history without improvements, without upgrades that have corrected those.
Anything further from Mr. Clark, Mr. Showalter? Okay. On Resolution 281 and the amendment as introduced, Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Nay.
Ms. Price?
Aye.
Resolution 281 passes as amendment. Thank you. Moving on into our public hearing. Of course, we are not at 6:30 mark.
Mr. Pack, that was just the amendment.
I was distracted by the cries of the angry mob outside in the lawn. So that is for the amendment now. 281 is before council as amended. Any further discussion on 281 as amended? Hearing none, Madam Secretary, please call the roll on 281 as amended.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Nay.
Ms. Price?
Aye.
Does someone want to contact the sheriff out front and tell him he needs to get outside? (281) passes as amended. Secretary, give me a read back of the vote on 281. Give me a read back of the vote.
The vote on 281 as amended was 4-1. Mr. Lesher was the nay vote.
Several public hearings going on. We're about to go into. I'm going to try to get through this. Hopefully, I don't want to have to call for a recess at this time. Before I go into the public hearing for the people at home, I'm going to ask if you want to speak at the public hearing. You need to call the number 833-491-0327. Please be advised that you're going to need to press the number 0 if you want to speak. You'll be placed into a queue in which Mr. Parker will then get your name and bring you up to speak to council. So, again, do not press 0 as soon as you call in. That's going to put you into the queue. If you want to speak, then you press 0, you'll be placed into the queue, and you'll be able to speak. So just want to make sure you understand that. Again, you're going to dial 833-491-0327. You can stay on the line and listen if you choose to. If you wish to speak, then you're going to press 0 and you'll be placed into the queue. Thank you. So we're going to start off the public hearing on Resolution 291.
Resolution 291, a resolution concerning the proposed rezoning by the Town of Easton, Maryland, the town of real property located at 29328 Dutchman's Lane, Easton, Maryland, 21601, further described as Tax Map 34, Parcel 91, consisting of approximately 1.696 acres, the property, finding that the proposed rezoning from Talbot County's Town Residential TR zoning district to the town's R10A zoning district upon annexation will result in substantially different uses or substantially higher density exceeding 50% than could be granted for proposed development under the pre-annexation county zoning, and waiving the 5-year hold in accordance with Local Government Article Section 4-416 of the Maryland Annotated Code.
Thank you, Madam Secretary. Madam Secretary, do we have a map of Exhibit E? Could we bring that up? Do we have that map?
We do.
Okay, so the area that we're looking at for annexation is the yellow area there. That's coming off of 50, going back past Corbin Parkway and going into the subdivisions there. So just for a reference point, that's where we're talking about the annexation into the town of Easton. This is the public hearing. Is Mr. Lynn Thomas on? Is Lynn on hold?
I am here, Mr. Pack.
Lynn, do you wish to be heard, sir?
Just briefly, I don't think I need to add much. We have the unique circumstance that the county is the party to the annexation. And I think the actual request is a lot simpler than the explanation often makes it out to be. We have a couple of circumstances with this application, and that it involves the transfer of ownership or jurisdiction of the road, and also the annexation of property, which doesn't come up very often, but is essentially the same process of annexation, but in reverse. Certainly, if you or the other council members have questions, I'll be glad to attempt to answer them. I can report that our town council approved all of their actions associated with this request, and the mayor has signed the resolution and ordinances.
Thank you very much, Lynn, for that update that the town of Easton has already, and also the mayor's already taken this matter up and approved the transfer of the roadway into the town of Easton. Mr. Parker, is anyone else on the call on hold for this resolution?
There are 10 callers on the line. No one has queued to speak.
Okay, if you wish to speak on Resolution 291, this is the public hearing. You need to press 0, and then you'll be placed into the queue. Mr. Parker will then bring you up and bring you onto the line to be heard. Okay, Council, it sounds like we don't have anyone else on the line. We'd like to thank Mr. Thomas for his input on there. Staff, anyone from you, or Miguel, anyone from you or from Mr. Clark on this transfer? Okay, Officer Law, anyone on this transfer of this property? Hearing on council, I'm closing the public meeting on the public hearing on the Resolution 291. This is a resolution that has been read a second time and is eligible for vote tonight. The chair will entertain a motion to move it to vote.
So moved.
Moved by Mr. DeVillio.
Second it.
Seconded by Mr. Lesher. Any further discussion on Resolution 291? Hearing none, Madam Secretary, call your vote on Resolution 291.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Aye.
Thank you very much. Resolution passes. Second matter for public hearing is Resolution 292. And Madam Secretary, when you get a chance, please read that one.
Number 292, a resolution authorizing the transfer of a portion of Dutchman's Lane to the town of Easton and authorizing the execution of a quitclaim deed to effect the transfer.
Okay, Mr. Cooper, so I think this just goes in partnership with Resolution 291. Is there anything further we need to gather from 292?
Nothing further.
Okay, we do have a public hearing for 292. Any callers on the line for 292? Okay, Mr. Parker, bring those up, please.
Okay, we have two callers on the line. The first one is Benjamin. I'll go ahead and unmute him.
Hi. Can you hear me?
I can hear you, Benjamin. Go ahead.
Is this about anything? Well, I
No, Benjamin, no, this is not the public comment portion yet, sir. This is a public hearing on Resolution 292. That is the bringing the Dutchman Lane into the town of Easton. Do you wish to be heard on that, sir?
No, I'll wait for the public comment to discuss.
Thank you very much.
Decision from earlier.
Thank you, Ben. Please stay on hold, then. We appreciate it. Do we have another caller, Parker, for 292?
Our next caller is Mr. Dappert.
Mr. Dapper, we're having a public hearing on Resolution 292. Do you wish to be heard, sir?
No, I'm in the same boat as the other person. I will wait on hold until public comment.
Thank you very much, sir. We'll see you on the other side. Council, it doesn't appear we have any other public on hold or here to speak on 292. I'm going to call 292 to an end. This matter is eligible for vote. It has been read a second time. The chair will entertain a motion to move it to vote.
I will so move.
Moved by Mr. Lesher.
Second.
Seconded by Mr. DeVillio. Madam Secretary, please call the roll to move 292 to vote, please.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Aye.
Okay, 292 is now before council for final vote. Any further comment on 292? Hearing none, Madam Secretary, please call the final vote on 292.
Mr. Pack, just a brief comment. This has been just a brief comment, sorry. This has been a long time coming. This is a long time work with the town of Easton to finally get this roadway turned over to the town to make it a town street and not a county road. We've had to jump through a lot of hoops. The staff has had to work a lot to make this happen, to bring the road up to town standards and to negotiate this. This started back when I was on the town council and a while while I was on the town council. This has been a long time coming. This is a really important thing, and we're going to be the better for it. So thanks to all involved in making this happen.
I agree with you completely. Madam Secretary, please call the roll on the vote on 292, please.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Ms. Price, I need your vote on Resolution 292, please. Aye. Thank you. Next matter before public hearing tonight is Bill 1462. Madam Secretary, when you get a chance, please read that bill.
Bill number 1462, a bill to repeal official zoning map 34 of Talbot County and reenact the same with an amendment designating the zoning district of a parcel of land shown on tax map 34 and described as 3rd Street on a plat titled De-annexation Plat, Town of Easton, 3rd Street right-of-way in the Town of Easton, Talbot County, Maryland, tax map 34, grid NA, parcel NA, prepared by Lane Engineering, Inc., and dated April 28, 2020. Such parcel consisting of 0.579 acres, more or less, from the R10A Town of Easton zoning district to Town Residential, TR, Talbot County zoning district, in part, and Town Conservation, TC, Talbot County zoning in part, which zoning designation is contingent upon the de-annexation of 3rd Street by the Town of Easton, Maryland.
Thank you very much, Madam Secretary. I don't believe we have a, do we have an exhibit of this one, of this? Okay. Parker, do we have anyone online for 1446? 1462, I'm sorry.
There are 11 callers on the line. No one has queued to speak.
Okay. This is, I'm going to go ahead and call the public hearing for 1462 to a close, since there's no one here to speak on that. This matter can be moved to, this bill can be moved to a third reader tonight. A chair would entertain a motion to move this to third reader.
So moved.
Second.
Any comment on the motion to move it to third reader? Madam Secretary, please read the bill. I'm sorry, Madam Secretary, please call the vote, please.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Aye.
Thank you. Bill 1462 is now before council for third reader. Madam Secretary, please read the bill.
Bill number 1462, a bill to repeal official zoning map 34 of Talbot County.
Council, I ask someone to be considered reading of the bill. Is there any objection? Hearing none, Bill 1462, excuse me, is now before council for final vote. Any additional comment? Hearing none, Madam Secretary, please call the roll on Bill 1462.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Aye.
Thank you. Bill 1462 passes. Next matter before council is the introduction of council discussion on the administrative resolution. This first resolution, Madam Secretary, Mr. Cooper Smith, I believe we're going to table as we made some changes to it after the governor's July 28th report. So, and I'm asking for that to be tabled, and then we'll go ahead and consider the introduction of the second administrative resolution. So, Council, the first resolution after the governor made his address regarding face masking basically made this particular resolution moot. So I'm asking for it to be tabled, and we'll be asking for the introduction of a second resolution which does incorporate some of the language that the governor had placed in his address on the 28th. And Madam Secretary, if you would please read the administrative resolution that's being introduced this evening.
Second emergency resolution, COVID-19 enforcement, superseding and replacing the emergency resolution on COVID-19 enforcement adopted by the Talbot County Council on July 28, 2020, requiring all persons in Talbot County to comply with the governor's executive order on face coverings and retail establishments issued on July 29, 2020, prohibiting service and congregating in bar areas, requiring the submission and review of a COVID-19 safety plan for certain large outdoor gatherings, establishing civil monetary fines for violations of this second emergency resolution, and authorizing the Talbot County Health Department and the Talbot County Office of Code Enforcement to enforce the requirements herein.
Going on up here. I'm shifting papers from one pile to the next. It's hard work up here trying to keep this thing moving. And, Council, there's one amendment I'm asking us to consider tonight, and this was after some conversations that I had with the health officer regarding face shields and face masking. I believe you do have the amendment. Mr. Cooper Smith did hand it out to Council earlier today during our closed session meeting. The amendment basically would, as it reads, is in the body of the introduction of the emergency resolution, and it reads, except that in Talbot County the use of face shields should not be sufficient to satisfy the face covering requirement in the governor's order. There was some concern that just the use of face shields would not give the protection that we need to prevent transmission. We do know that the governor did, in his, again, July address, did speak about the use of face shields, but we felt, again, in conversation with the health officer, that just solely the use of face shields would create the possibility of transmission. You can certainly wear the face mask and the face shield. That would give you an added protection. I know I read the recent emergency declaration that was issued out by Chief Judge Barber for the Maryland courts. And she also has indicated that the use of face shields alone would not be permitted in any of Maryland's courts. So I think that we are consistent with her order, and to be on good ground with this, I'm offering up also this amendment to the emergency resolution. Okay, if there's no further discussion, I'm going to ask for the vote just on the, for the amendment alone. You all have the amendment in front of you. Again, I just explained.
Mr. Peck, should we? Well, I know we've gotten anything written. Do we want to hear from our health officer on this particular amendment and the need for it?
Dr. Wiley, I saw that you had come into the room. Do you wish to be here on the face masking or face shield? Okay, I'm going to translate. Dr. Wiley, that's fine. Dr. Wiley said the CDC also has said that the face shields alone are not a effective or way of preventing the transmission of COVID-19. So we just want to make sure that we've heard from a health officer on that. Dr. Wiley, thank you for being with us. Anything further from council? Yes, it's just on the amendment. Madam Secretary, Chair asked for a vote on the amendment only for introduction of the amendment by show of hands. I'm sorry. By Mr. Lesher and myself. Okay, the chair now want to entertain, is any further discussion on the amendment to the emergency resolution? Hearing none, the chair will entertain.
Mr. Pack, this is an area where I lack professional expertise, and so for matters like this, I do rely on the professional expertise that we have in our health officer, and I really defer to that expertise in making this vote.
As well as I. Again, she's welcome to come to if she wishes to be heard. She did give us her input regarding the CDC, but I don't want to drag her to the table. Dr. Wiley, you will have to push the button and hold it, which all the mics have been muted.
Yes, okay. So I just wanted to say that, this is not my opinion alone, that it has been said that you do not get the same protection as from a mask, okay? Not only that, but you need to clean that mask frequently, or it's even a greater risk for the person, okay? So more and more they're doing studies on the mask and how it can protect the others as well as protect the individual. And we know that the face shield cannot be substituted for the mask and be equal. It is less than. And so that's all I wanted to say, okay? And it's not just one individual. It is multiple individuals that have said that and shown that.
Thank you, Dr. Wiley. Any further, Dr. Wiley?
I'd like her to say, I'm going to have one more question after the amendment.
Chair, are you satisfied, Mr. Lesher?
Indeed. Yes.
The chair would now entertain a motion on the amendment to the emergency declaration.
I'll move the amendment.
Moved by Mr. Lesher.
Second.
Second by Mr. DeVillio. Any further discussion on the amendment? Hearing none, Madam Secretary, please call your roll on the amendment.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
No.
Mr. Lesher?
Aye.
Ms. Price?
No.
Okay, the amendment passes. Okay, so you now have your emergency declaration amended. Is there any comments or any questions on the emergency declaration that we have before us this evening?
I have a question. So I reached out to Dr. Wadley with this, and we had a little bit of a communication back and forth. I was hoping to get a little clarification. We had listed the 50 for purposes of this section, large outdoor gathering, meaning a gathering more than 50 people held outdoors in the unincorporated area of Talbot County. And you had a couple questions about if this includes a wedding caterer with 50 with the caterer, or if a wedding reception with 100 inside without a permit, and those kinds of things.
Push the button. I recognize that you're dealing with leaving the governors for inside and dealing with just outside because there was nothing there. So I recognize that. But yes, the outside is better as far as if you have the same number.
Okay, thank you. Any further questions?
We had also gotten some advice from you about the enforcement provision, suggesting that we drop the one that calls for, on a fourth offense, suspension of the food service license, because you already have the authority to do that, and you do not necessarily need to wait for 1, 2, 3, the fourth offense to be able to do so. That by not doing this, we would leave you that discretion that you already have. That by not including that in this, you would have the discretion to do that or not do it, which an authority that you already have under law.
On the food service thing, that's already there.
Yes, any further questions? Okay. Chair will now entertain a motion.
Sorry, one more clarification. So these, we were referring to civil penalties to cover Talbot County. So and that was clarification you were asking me. So this would take This would do civil penalties over the entire unincorporated portions of Talbot County. That's was our intention with this. Is that correct? I'm sorry.
Good question. I thought you were talking to Dr. Wiley. I apologize. I was reading. What did you say?
Just making sure these were civil penalties to cover all of Talbot County, not just the incorporated portions.
Yes, that is good. The civil penalties would cover all of Talbot County. Yes.
Okay. So I would.
Guys?
I would be okay deleting letter D under section 11, just out of redundancy. The fourth offense, if the violator holds a food service license, that would have already been done.
I will second the motion.
Can you all hear me?
Yes, Mr. Price. We have a motion to remove letter D on page 4 regarding the food service license. Dr. Wiley already has that under her food service article to do that, so there's no sense in putting that into the emergency declaration. Motion made by Mr. DeVillio, seconded by Mr. Lesher. You have comment?
Just general comments, the whole thing. As we've gotten news from the governor's office that the incidence of COVID-19 cases is dropping, and our data is exactly the same as the state, I cannot support adopting more stringent restrictions than the governor has imposed. As Dr. Wadley states, that there is no magic number of people that is safe. I see no justification to intrude on people's lives any more than we must. The governor has imposed restrictions, and I believe we should follow those. In the absence of data related to the age groups that are being infected or hospitalized in Talbot County, I am not prepared to impose any new measures stricter than the state. And we need the same level of detail for Talbot County that is listed on the state website.
Okay. Anything further? Yeah, I'm going to go back to that. Thank you very
I'm sorry,
much,
on the
Mr.
motion
Lesher.
to defeat
We have a
11B.
motion and a second to omit letter D on page 4. If there's no further discussion, Madam Secretary, please call your second. I'm sorry. Madam Secretary, please call your roll to omit letter D on page 4.
Mr. Pack? Aye. Mr. DeVillio?
Aye.
Mr. Callahan?
Aye.
Mr. Lesher?
Aye.
Ms. Price?
Aye.
Letter D has been omitted from the document. Any further discussion on the emergency declaration?
I just had one question from our Parks and Recs director. If this would be the 50, the gathering outside, if that would take into account the Parks and Rec camp programs or outside activities. So if he was over 50 and there's paid admission, it's obviously open to the public, they would, right. So then they're going to meet with and put together, they should put together their own plan first and come to you with how they would like to show that it will be safe, and then, okay.
Okay. Anything further?
Yeah, I got a question for Dr. Wiley. So, last week, you made a couple decisions on a couple businesses to pull their license. Am I correct?
You're right. Two businesses, we suspended the temporary suspension of their license for non-compliance of COVID precautions.
Yeah, I got you. I got you.
And let me just say that was done as I said, with a COMAR regulation now, giving the health officer delegated authority from the secretary that if health threat exists, that they can summarily suspend the license. I want you to know, though, that on these two, I had well over 10 complaints on each and well over 5 contacts by staff trying to discuss and talk them into using the mask. That's not the only complaints we've had, but definitely by far these were the greatest. Both of them requested, as their right, to be re-inspected, and one was done today, and the other one requested Wednesday because the Amish market is not open until Thursday. They had a right to appeal, but definitely wanted to go that route. And so, yes, we started that. We wanted those that were very flagrantly saying, I'm not going to wear a mask, that others were doing it, and that was their responsibility also to do it.
Thank you. And I want to stress that this is a stressful time for you, and you're making these very difficult decisions with these businesses. So I'm struggling a little bit with this emergency order because I sort of feel like you're already doing the job. Why do we need this on top? Because it seems
we were job. Nothing you can do but come back and ask again and educate and educate. They tend to just brush you off. And that's where we had gotten with these two businesses. And so, you know, you're hopeful. This happened in Worcestershire County, where there was a lot of problems, and it only took one or two to the rest of them also believe that it could happen. And as I said, we're not going in and you find one person with a mask off and you take their license. No, it is the persistent and violations and refusal to comply that's the ones that we're interested in.
I really appreciate, and I feel like I'm not on board with this because I feel like you're doing a good job now, and you've already got the power to shut some of these businesses down.
I think that, you know, a lot of them look at the way that the governor's order says that you can do this, that criminal citation. That's rougher than the other one, okay? And much more involved. It is a criminal citation, goes through court, and I would hate to use that one, okay? I think this is milder, but still enough to get their attention.
Okay, if there's nothing further, the chair will now call the vote on the amended emergency declaration. Madam Secretary, please call your roll.
Mr. Pack?
Aye.
Mr. DeVillio?
Aye.
Mr. Callahan?
No.
Mr. Lesher?
Aye.
Ms. Price?
No.
Okay, Dr. Wiley, thank you very much. Appreciate it. I need to call a 5-minute recess. Please join me in the side room. We're going to step away for 5 minutes. Back in session. Going to be suspending the balance of the council meeting this evening, and we understand that citizens are quite upset over the earlier vote taken today, so council is going to go ahead and suspend the balance of this meeting. Basically, we're at the end of the meeting. I know there's been a number of people online for public comment. We'll certainly take any comment in writing that persons will have. The issues that the county manager had in the county manager report, none of those issues are time sensitive, so they can wait to be addressed at the council's next meeting. So with that being said, Madam Secretary, we're going to suspend the meeting at this portion. If there's no objection from council, the chair will call for an adjournment. The council is adjourned.